All right. So we've called the meeting to order. Let's start with our roll call. Commission, time is 6:02 according to the clock in the back. All right. We start the roll call with Commissioner Barrow, who is traveling. All right. So we've called the order.
Play by play.
All right. So we'll start. Commissioner Barrow is traveling, so she is excused. Commissioner Edward?
Here.
Commissioner Baldwin?
Here.
Commissioner Tagliapetra?
Present.
Commissioner Martinez? Here. Commissioner Haywood?
Yeah.
And Commissioner Homan here. All right. Has everybody had an opportunity to look at the agenda? Are there any corrections, updates, additions? And if not, can I hear a motion for adoption?
So moved.
Okay, is there a second?
Second.
All right. The motion has been moved by Commissioner Baldwin and seconded by Commissioner Tagliapetra. This is a roll call vote, as always. Commissioner Edward?
Here. Yes, I approve.
Commissioner Baldwin?
Yes.
Commissioner Tagliapetra?
Yes.
Commissioner Martinez? Yes. Commissioner Haywood?
Yes.
And Commissioner Homan, yes. All right. So next thing up on our agenda is a presentation on the 4th Street project. And I believe Ms. Rinaldi is going to give it to us.
It is my pleasure to do a project update for you guys as requested on the 4th Street Revitalization Project. I have just a few slides, but I'm mostly just going to speak to you. The project is fully engineered and designed, and it is 3 subsequent phases to what's already been built between Schulte and Pueblo Solano. So it continues from Pueblo Solano all the way to the village limits at about approximately Ortega. Phase 2A is Pueblo Solano through the intersection of Ranchitos Road. Phase 2B is where that terminates, either the south side of Paseo del Norte Bridge or to the north side, yet to be determined on whether or not NMDOT is going to participate in some bridge improvements in that phase. And the final phase, C, is from either side of the bridge to the intersection of Bernalillo County's road diet, which is coming south from Alameda Boulevard to ours, with the same configuration of a road diet, reduction to 3 lanes, which is 1 travel lane in each direction, with a continuous turn lane. There's differences in there. They don't do landscaping, lighting. They do have a bike lane, and I'll talk about that towards the end of the presentation. But what you see up here is the typical section of the design that was selected through 8 sessions of public input and final approval, final adoption by the Board of Trustees in September of last year, of 2024. And this typical section shows you 5-foot wide sidewalks. So before the sidewalk, it's a 60-foot right-of-way. So there's 1 foot before the 5-foot sidewalk, which is P&M poles. They have to be moved off of the sidewalk area within the right-of-way. So there's 1 foot before the 5-foot sidewalk. There's a 2-foot space between the sidewalk and the swale for the pedestrian lights and roadway signage. Then there is the landscape swale, which accommodates the stormwater drainage system, transmission system, collection and transmission system, as well as the landscaping and street furniture and the like. And then there is a 2-foot curb that's between the swale and the driving lane. Driving lanes are 10 foot. The continuous turn lane is 11 foot, and of course it's reflected the same on the other side. The next one, please, Darnell. The design elements, there are many design elements and landscape plant palette reflections from phase 1 continuing over into subsequent phases. Again, this is continuing all the way through to Ortega. And the plant palette, it builds on what is planted in phase one, but it also, we added in things that give us seasonal color throughout and that are adapted to be able to deal with occasions of stormwater flooding in the swale where the landscape will be placed. The trees are strategically placed to keep clear line of sight at all intersections and wherever necessary for pedestrian safety as well as vehicular safety. And the next one, Darnell. And a lot you'll see reflected in the site furnishings and materials. We have the same bus shelter, the same street furniture from the benches to the trash cans to the pedestrian lights. The string light sections going north, the only difference between them is they have an encasement that directs the light down. Contrary to public belief, the phase one does meet the night skies ordinance and statute of the state of New Mexico, but this one does direct it downwards so that there's no glow. But it still provides the safety and the ambiance of lighting in all the areas where it is. There is pedestrian lighting throughout. There are sections of stream light, just like there are in the first phase. What else can I say about that? Oh, the materials, colored concretes, brick pavers, the Riccabini cobble, and then of course all the different kinds of rock in the landscape areas. So whereas phase one is brick sidewalk and colored concrete accents at intersections and in different areas, it's the reverse going north. It is colored concrete with brick at intersections and at bus stops and other areas where we are drawing attention for pedestrian safety. And the cobblestone, whereas in phase one, it's part of the stormwater collection system. It has a permeable paver, a permeable grout. The pavers are not permeable. It has a grout system that allows water to go into the stormwater system. It is strictly for aesthetic. This is a decorative element in the next phases. It's in driveways to indicate where there's a pedestrian break where vehicles have access to private and public properties and commercial businesses, but it is not part of the drainage system. It's purely decorative. And I think that's all I'm going to say about that.
Before you move on, so is there a drainage system?
Yes. There is a, do I have that in my slides? So can you go back to the first one, the typical section, please? There's a 2-foot curb between the swale and the drive lane, and there are curb cuts throughout that allow the storm water to flow as engineered based on slope of the road that directs the water into the swales. There are collection systems within the swale, within the landscaping that collect the water and take it into a transmission pipe. And what is not absorbed in the landscape areas goes into, there are two ponding areas, underground pond, and then there's a major pond area at the intersection of El Pueblo and 4th Street. And I'll talk a little bit about that in one of the other slides. So yes, so it's all integrated into the swale, the landscape, the drain, the stormwater collection and distribution and transmission to facilities. And I'll talk about that in the acquisition of right-of-way part of this. And Darnell, I forgot where I am, so there you go. So at this point in time, we have funding for phase 2A. Again, Pueblo Solano through the intersection of Ranchitos Road. And the reason we're going through the intersection is something I'll discuss when I talk about right-of-way. We have acquisition of right-of-way funds, and we are purchasing 5 properties, 5 portions, 3 portions and 2 properties within the project area. In the phase 1 portion, we're purchasing a property in whole for underground storage, water storage facility, stormwater facility. And in subsequent phases, well, the easiest one to, well, at the intersection of Ranchitos, we're purchasing a portion of property to create a designated turn lane to serve the turn, if you're south, well, both ways actually, dedicated turn lanes to serve the development that includes the Village Academy. So that's an acquisition. And we have a couple of, three acquisitions at the intersection of El Pueblo and 4th Street. And I'll have a slide directly for that. But we have all funding secured for Phase 2A. We have no funding for Ranchitos to Paseo del Norte or from Paseo del Norte to Ortega at this time. There are funding opportunities coming up in the next 1.5 to 2 years that we will be applying for, but at this point in time, those are completely unfunded. The engineering is done. It is under review, final review by New Mexico Department of Transportation. And we have what's called fiscal constraint. We have to prove that, based on our engineer's estimate, that we have funding secured to cover that. And at this point in time, our latest engineer's estimate, a little bit different than what's on that slide. The engineer's estimate for Phase 2A is $9,848,000. And our funding secured is $10,175,000. So that's actually increased since this slide as well. And again, no funding secured for subsequent parts of this project. And the schedule, this is pretty much holding except for the Board of Trustees did approve the design in September of 2024. Right-of-way acquisition is underway right now. We're making offers on appraisals that are completed on the acquisitions that I discussed, and we are in utility coordination for relocations. We've already determined with the utility companies what needs to be moved and where it's going to be moved to. And we have movement by PNM on their poles. We have Gas Company of New Mexico relocating their gas line. And we have the utility authority moving fire hydrants and water lines. That's the big one. And many of those relocations will occur beginning in August. Some of them may occur concurrent to construction. And you can go to the next one, please. In future phases, we have the funds for and will be acquiring the 3 necessary acquisitions to make the roundabout and the storm drainage pond, the harvesting pond, a reality. So that will occur, the acquisition will occur in this phase of right-of-way, but nothing will be built until that's funded. But we're acquiring the entire property in the northwest corner of that intersection. We're acquiring a small piece of property through what is an existing drainage system at the apartment complex on the northeast side of the intersection, and we're acquiring a sliver of property to make the radius of the roundabout on the Blake's property on the southeast section. These are all under appraisal and offers will be made for acquisition. And the final slide is, this is a little, sorry, this is the only thing I could come up with to show you guys on that. Bernalillo County's intersection with the Village of Los Ranchos. Configuration for travel lane and center turn lane is the same. They have a bike lane, we do not.
I'm not clear, where is this?
This is Ortega
Oh,
and 4th Street,
oh, okay.
where the 2 projects will meet. We are still designing a termination of their bike lane well into Village of Los Ranchos project area that at this point will terminate at the Paseo del Norte on the south side to connect to the trail system. We're still working on that. So that will be one slight change to our configuration when we have final design done on this section. And depending on when they are ready to bid their project, there is the potential that the village may construct 2C before the center section, just to make that so that it's not just a dead-end bike lane, just to make that connection safe for bicyclists as well as everybody else in the corridor. This shows the offset. We couldn't meet the merits of a signalized intersection there, and we didn't have the right-of-way or the ability to acquire right-of-way for a roundabout. So this is a Hawk signal system, because the bike lanes, they're on both sides of their project, but it's gonna have to move over to the west side to traverse to Paseo del Norte. So we've come up with a Hawk signal for pedestrians and bicycles to make that intersection safer. Safe median for half crossing and then to cross on the second half of the signal. Yes, ma'am.
Commissioner?
Is this more like the crossing in Bernalillo, town of Bernalillo, versus more like than ours? Because those flash and bip and do all things, and ours don't, do they?
Madam Chair, Commissioner, these did flash. You can't see them during the day. I don't know what's up with that. But we did put the signaled signs on the crosswalk there by the parking lot, so you see the flashing signals there now. But this is a push button signal that stops traffic
Okay.
for bicycles and pedestrians, and it's offset to give a larger island of refuge for pedestrians and bicycles. But this is actually an I built the one in Bernalillo, but this is actually an improvement to that one.
Okay, thank you.
Yes. What else can I say about that?
Ms.
So that's-
Rinaldi?
Yes.
Commissioner?
First, thank you for the presentation and the update. It's really nice to hear about the progress. And also, I really appreciate the thoughtfulness around the bike lane connections, so we don't end up with something just sort of dropping off in the middle of the universe, as well as the consideration of maybe how to time things with Burn Coast, so we don't have a road diet and then a raceway and then another road diet far down into the village. What is the timing for their work? I may have missed that in your presentation.
Madam Chair, Commissioner, they are at 90% design. So they have funding. So we have a coordinating meeting coming up with them this coming quarter, which is July. So I'll have an update to that in the next few weeks. But I'm sure well before what we were planning on in our subsequent construction. So it's more likely that we will construct that section before the middle part. But to your point of road diet, raceway road diet, the village is currently, we have a restriping plan for the corridor as an interim measure to stripe, yes, to the configuration. So
Thank
to
you,
eliminate
thank you,
issues
thank you.
such as that. We're soliciting quotes right now. We have to erase the markings that are there, first of all, as for obvious reasons, and then restripe it. And those quotes are being acquired by the village now.
Thank you.
That is all I have, unless you have any questions.
Oh,
I want to go to what's going on in phase 1, 2, and hopefully try to get an understanding about one of the things that I really respect and appreciate is the landscaping. And as we've seen, you guys, and I don't know who the word you guys are, take care of it very well. Without that, we would run into one of the most unique, ugliest things that you can see. And I just want to make sure that, is that contiguous for the existing life of the street projects? The landscaping, the care of landscaping, number one?
Madam Chair, Commissioner, the village contracts out for maintenance on that, and it is the intention of the village to maintain
Continue.
that in perpetuity.
Good. And the second one is the lighting situation. Because there's one at the beginning of 4th Street that has been down for a while. And so I know it's all about maintenance. Is it the same concept that the village is the one that's responsible for the lights that go out on that beautiful crossing that we see above us? And if it's damaged like the one at the beginning of 4th Street is it, how long does it take to get repaired? Because I think that's one of the most beautiful things as you drive in is the look of it and the landscaping. And I'm just kind of following up of wonderful. It's opportunity for landscaping. The lightings, I see a lot of single lights just left out in the beginning that isn't or needs to be replaced.
Madam Chair, Commissioner, I happen to know because I was in a meeting with the maintenance staff and the administrator and the rest of the staff this morning that I believe that maintenance has found a contractor to take care of those issues. And they are being dealt with. But yes, of course, it is, again, in perpetuity, the village intent to maintain all of the facilities.
Thank you.
Thank you. Any other questions?
Hi. Thanks for your work. One of the concerns I have is those perceived crosswalks don't really provide any degree of safety to the individual, but it, to the unknown user, provides some expectation of an assurance of safety, which I think makes it terribly dangerous. And I don't know if there's going to be those changed or modified to provide a greater level of awareness to the automobile driver, and how are those going to be different on the project itself. They have these little thin lights about that big, about that tall, that barely stick up out of the ground, and they're supposed to flash when you press the button. You can't see them in the daytime and even at night. And so when they're flashing, I take on the role of leading my kids across, and cars are not looking at that. They don't stop, they don't care to stop, they don't want to stop. And so I think you got to have something a little bit more bold, and I don't know if that's the expected plan or if there's any modifications to that, but I think that it creates an air of safety, but it actually is not safe.
Madam Chair, Commissioner, to address those concerns, we have modified many of the crosswalks in the next phase. There is larger signage, for one, and the crossing at where the Chamisal ditch crosses 4th Street in the vicinity of,
My neighborhood,
what's the name of the road?
Rincon Hacienda, Nuevo Hacienda Lane.
Nuevo Hacienda Lane, that is a raised crosswalk, a full raised crosswalk with hawk signage, and they have larger refuge areas on these crosswalks as well. So yes, you know, with speed reduction, with the narrowing of the roadway, it still often comes down to a level of enforcement that we're very happy to see out there now with Bernalillo County. So it's just a combination of driver awareness, driver responsibility, and doing a design and engineering that we, as much as we can, to raise the visibility of those crossings.
Yeah, and I don't want to be too critical. I mean, I think that the intent was to make it look not too obtrusive, but it erred on the side of incognito too much.
Madam Chair, to that point, these are striped crosswalks. They're not colored concrete crosswalks. These are full visible striping, the reflective striping. And so that's a big difference as well.
Great. Maria, is there any plans to restripe the first section then to make it a little more consistent, and since there are these acknowledged issues, just to raise the safety level?
Madam Chair, just because I was in that meeting again, I know that Keene is soliciting costs, or he actually may already have the costs, but he's scheduling the replacement of some of the striping and turn arrows in phase 1. But you'll notice that we striped the crosswalks in addition to the colored concrete, because they were not visible enough. So yes, there are improvements pending for that as well.
All right, and when should we expect shovels to be in the ground on this 2A project?
We anticipate that right-of-way acquisition, we're hoping that it'll be complete by end of August. And once we have right-of-way acquisition, we can move forward to preparation of bid once we have determined what utilities are going to be moved prior to construction and which ones are going to be moved during construction. So our right-of-way schedule now completes, I'm sorry, I meant to say appraisals and offers, end of August.
Okay.
So acquisitions, we're hoping for September of this year to let the bid. That will probably slip a little bit, but we're holding to that right now for bid. And because the storm system is in the progression of construction, the storm system is going in first. you can do that during the winter. So weather is not going to be an issue. It's not, if we bid this in September, October, we award in November, December, they can start construction because the first phase in the progression is a system that can be constructed during winter weather.
Great. Commissioner Edward?
Oops. I think there's a safety problem and an economic development problem in that we have no cell phone service for most of the village. And to the extent that that's the case, is there anything being done with these lighting poles to create a 5G technology built into those poles so we can actually get more than 0 or 1 bar? Or has that been brought up? I don't know.
Madam Chair, Commissioner, it was not part of the scope of the project.
Can it be?
Madam Chair, Commissioner, at this point, no. We have our fiscal constraint, we have our design, and we have the funding that matches the engineer's estimate, and it is, we don't have any funding to add to that.
Okay, well, I would just say in the future, whenever we're doing projects like this, that we look at that to the extent that people have, I think, the expectation was 1 cell phone per residence. I think it's 6 or 7 devices per residence. And I go to the businesses along the village thoroughfare there on 4th Street that are supposed to benefit from this, and there's no cell phone coverage.
Madam Chair, Commissioner, I have something to add to that. In our discussions with all of the fiber and network providers, we highly encourage them, based on the franchise agreements, to bring the most contemporary, the most up-to-date that they can into the facility. Everything is going overhead now. It's overhead and towers. I know that some of them are looking at improvements. So there's the potential for that. In our next coordinating meeting, I will directly ask that question. If any of their upgrades, how it impacts capacity within the village.
Because I wouldn't locate my business on 4th Street right now because I rely on my cell phone and I don't get any cell phone reception in many places along 4th Street.
Yeah.
And that's the way most businesses operate. I have a client, they have 15 people, they have 1 line, and they compensate the people who work for them to use their cell phones. And so I don't think that we can be a community of the future if we don't have that. And it's part of the infrastructure network that we live in, and I think that it should be incorporated into projects like this. So that's my preachy.
Appreciated.
Thank you very much, Maria.
Certainly.
Thank you.
So moving on, we will go to the consent agenda. So all matters listed under the consent agenda are considered to be routine and will be enacted by one motion. There will be no separate discussion of these items. If a discussion is desired, then that item will be removed from the consent agenda and will be considered separately.
Madam Chair, I would like to discuss the April 8th minutes separately.
Okay. So with that, is there any desire to separate and discuss anything on the May 13th minutes? Okay. So approval of the minutes underneath the consent agenda at this time right now is going to be on the May 13th, 2025 regular P&Z meeting only. We will discuss separately the April 8th meeting minutes. Is there a motion to approve the May 13th Planning and Zoning minutes?
I'll make a motion to approve May 13th, 2025 Planning and Zoning meetings minutes.
Is there a second?
Second.
Okay, it's been moved by Commissioner Tagliapetra, seconded by Commissioner Baldwin. All those in favor, we will do once again a roll call vote. Commissioner Edward?
Yes.
Commissioner Baldwin?
Yes.
Commissioner Tagliapetra?
Yes.
Commissioner Martinez?
Yes.
Commissioner Haywood?
Yes.
And Commissioner Homan, yes. Now, as per the request of Commissioner Baldwin, we will address the April 8th, 2025 minutes.
So, Madam Chair and Commissioners, as you are aware, there were several updates to the packet. And so I just wanted to put on the record that the current posted minutes in the packet accurately reflect the work that was done at the May 13th meeting, and specifically on page 5 of 12 of the April 8th minutes, the issues related to the purpose section around clarity to add "or into" before public rights of way is corrected in all the 3 places where it appears. In the suggested for clarity on line 32, in the motion on line 33, and in the actual purpose statement itself on line 41. So I just wanted to make sure that people know it was posted and we can act on the corrected minutes.
All right, are there any questions about Commissioner Baldwin's statement? Okay, seeing and hearing none. Is there any further discussion regarding the April minutes? Seeing and hearing none. Is there a motion to accept as presented, which has now been verified, it has been correctly done?
So moved.
Is there a second?
I'll second.
Okay, it's been moved by Commissioner Baldwin and seconded by Commissioner Tagliapetra. Once again, this is a roll call vote. Commissioner Edward? Yes. Commissioner Baldwin?
Yes.
Commissioner Tagliapetra?
Yes.
Commissioner Martinez?
Yes.
Commissioner Haywood?
Yes.
Commissioner Homan, yes. All right. Let's get up here. Okay, so we are on the public hearings now, correct? Or did I go too far? Pardon me? Oh, public comment, I'm sorry. Public comment. We have nobody that has officially signed up. Is there anybody in the audience that didn't have an opportunity to sign up that wishes to speak? Seeing and hearing none. Darnell? Is there anyone online that wishes to speak during the public comment? Thank you. Let the record show that there were no public comments. All right, now we will go on. Make sure I've got this in here. Okay. We are on our public hearings. So our first and only item is TA 25-01, which is a request by the Village of Los Ranchos to amend the text of 9.2.3 definitions, 9.2.6 transfer of development rights and regulations, 9.2.13 gateway district zone, 9.2.14 village center zone, 9.2.18 off-street parking regulations, and 9.2.22 signs of the comprehensive zoning code to remove duplicate and unused terms, modify existing formats for consistency and clarification, and update all standards to meet applicable specifications and requirements. Initially, this was heard by the Planning and Zoning Commission at our April 8th, 2025 public hearing. So, Mr. Brennan, Mr. Williams, will you give us a planning and zoning report or a planning report on this, please?
Test. Thank you. Madam Chair, thank you. Appreciate the introduction. For the record, my name is Brennan Williams. I'm a independent consultant assisting the Planning and Zoning Department. With staff support, we'll be presenting this matter tonight. Madam Chair, you're correct. This was originally before the commission back in April. On page 3 of your staff report toward the top, there's an outline of items that were discussed and considered by the commission during the public hearing, and changes were made to the proposal. That is outlined in attachment 1 of your packet. That originally, if you'll remember, was the what I called the red line, blue line version. Red line meaning items that were proposed to be stricken or removed. The blue line were items that were to be added. I've added another color. The green line that is now listed in, or the green lined items that are now listed in attachment 1, which reflect, again, at the top of page 3 of your staff report, terms that were either modified, pulled back in. There were a couple terms that we had proposed to remove, and after discussion, determined that it was necessary that they be left in. are outlined in attachment 1 in green text. Additionally, there was some discussion by the commission concerning the amortization period that was both existing in the, or that is existing in the current code, as well as changes to the sign code to allow that to remain. Specifically, there were questions about how did that come about? And secondly, what sort of action, if any, did the village take to enforce that? Since the publication of the staff report and the items in the packet, the village and Mr. Chappell have proposed additions to the general sign regulations. We can get into those as the commission would prefer, but there is some clarity that's offered on the amortization question, as well as suggestions from council as to how or recommendation to the commission as to how to incorporate those general sign regulations. That being said, in conclusion, Madam Chair and Commissioners, the department still is recommending that this body make a recommendation to the Board of Trustees based on the changes and the modifications to pass a recommendation of approval along to the Board of Trustees. As I mentioned back in April, this is really kind of a two-step process. Begins with the Planning and Zoning Commission. We vet it here at this level, and then we pass a recommendation on to the Board of Trustees. So staff is, again, proposing that this matter be pushed or pushed on to the Board of Trustees for their consideration with a recommendation of approval from the commission. With that, I will stand for any questions.
Thank you, and thank you, Brennan, for the comprehensive staff report. I wanted to follow up on a couple of items just to get clarification coming out of the action of the April 8th meeting, as well as what you referenced, the last-minute communication that was sent to P&Z commissioners about amortization. One, the attachment 1, page 50, that's the purpose statement in the red line, just confirming that it will read, as we've just discussed, or into public rights of way. The original red line, green line, blue line had and instead of or. So just confirming that that is a part of the adoptable document.
Madam Chair, Commissioner Baldwin, yes, ma'am, that's correct. There was an email that I sent out on Friday that referenced the minutes, the red line, blue line, green line version, as well as the clean version. But yes, ma'am, that will include the term or rather than and as motioned and adopted by the commission from April into what goes before the Board of Trustees.
The second is the variance procedure for the sign code. We talked about the possibility of an administrative process to address small deviations before something came to planning and zoning. So Brendan, is there a current timeline or a process underway to make routine changes or updates to the zoning code that this could be added to? Since it wouldn't be coming to us, since it's an administrative process, I just am curious to know if that can be handled.
Madam Chair, Commissioner Baldwin, thank you for the question. Yes, believe in April I had discussed, there was some discussion initially about a procedure within the general sign regulations, a variance procedure within the general sign regulations, and after discussion, one of the ideas that I came up with, just kind of on the spot, was that I'm familiar in other jurisdictions around the state where they have a process that is similar to the variance procedures. So an applicant is seeking some sort of relief or a waiver to the standard, but it's not called a variance. To answer your question, yes, we're still working on that. I think I've mentioned to the commission before that when the mayor first came into office, he sat down with Administrator Avila and I and asked, what are some changes that we need to make to the code? And we had identified 8 or 10 different things that we suggested needed to be worked on. The mayor kind of prioritized that, deviations has been added to that list. So we will come up with the administration will come up with a process, and eventually it will be presented to this body, much like we're doing tonight, for their consideration, their discussion, to establish or determine if we need to establish the process, and if so, what is the process, what are the regulations, what are the thresholds, things of that nature.
Thank you. I appreciate that. The bigger question I have is the amortization research that you included in the report. I have to say it's a bit unnerving how little information you were actually able to unearth in past records and how little context for past actions were available from amortization period to enforcement. And as a side note, I am really aware of the staff load that everyone has right now, and it seems like the village desperately needs to create a library of codes that shows changes over time, ideally with electronic files, but let's just put a pin in that one. I think the bigger question is the information. I'll turn my questions to you, Attorney Chappell, that there was additional research done that was unfortunately not completed or shared in time for it to be integrated in the staff report, indicating that case law would require just compensation for required removal of billboards and portable signs that were in place as of May 19th, 2008. That was sort of the last moment in time that was sort of a starting spot for the prior amortization period, which ended in 2011. So I do understand that what you're saying is that any amortization period would have costs associated with it and enforcement, that just compensation. And that the request is that no new amortization period be added to the sign code. And so I'm trying to understand was there any research done on what that just compensation would be? I mean, are we talking $150? Are we talking millions of dollars? How is that evaluated? Because while I think we have to be mindful of costs that become impositions to the village, we also need to have the ability to update and have our code reflect the village that we want. And so we need to understand what that choice point is. So do you have any of that as part of your research?
Madam Chair and Commissioner Baldwin, let me start with the background that this sign ordinance project was initially taken on to get our sign ordinance in compliance with the constitutional requirements. And so that's where a lot of the effort has gone. Some of the other sections that we ended up getting into have been a little bit more piecemeal. I've had some outside counsel on the constitutional issues. But here's the problem or the issue that we had. In the old ordinance, we had two conflicting provisions. One of them said that all signs in existence in 2008 on billboards, we're talking about billboards, must be removed by March 31st of 2011, which was this amortization date. Another section of the ordinance said signs exempt from this section are those that were in existence on May 19th of 2008. So we had an exemption and we had a amortization period. And I think some of that was caused by confusion in the case law. And this is what we finally ferreted out as to where we are. About 1981, there was a section added to the condemnation code, not in the village municipal code, that said that signage could not be removed without payment of just compensation. That was initially thought of in the context of a condemnation case. After that law was passed, the city of Albuquerque had a case in which it required by zoning that a sign be taken down, and it went to court, and the court said that the municipality had the power under its police powers, the zoning, to require the removal of signs, and if it was under the police power, there was no compensation due, but this amortization period, which allowed somebody to use the sign for a period of time after the ordinance was passed, was sufficient to keep it from being inequitable. Okay, so that was a standard, and there's a lot of case law around the country that talks about that, and it typically picks like a 5-year amortization period. So I think that was kind of where it was when this ordinance was done. I didn't draft this ordinance, but I did comment on it. But it did have that conflicting provision. So when we got into that, there was another case that was decided a short time thereafter that had simply not come to the top. That was a Supreme Court, New Mexico Supreme Court case that said the condemnation test also applied in the city situation under the police powers. And the city of Red River took that argument that it did not apply because of the police powers. The court held that because the police powers are derived from statute, because that statute in the condemnation section put that requirement is that the village, municipality, whatever, had no police power to exercise a right to take it down without just compensation, okay? So that puts us in the position we are now, and frankly, I just figured this out because we were trying to figure out that the case law seemed to be all kind of on that plane that 5 years was adequate, but we have this one case that is our New Mexico Supreme Court case that says any removal of the sign that was existing or was properly permitted, you must pay just compensation to remove it. So we are not proposing to condemn or remove any of those signs, but rather until there is a change, which the law says, they are entitled to exist. So we have removed that amortization period that we had put in, was going to be the 5 years, and reinserted only one of the provisions in the old ordinance that says those signs are exempt from the provisions of this code for compliance, which I think is an accurate statement of the law. And so we've just worked through that process.
So in the suggested language that you sent out, it all refers to section N, and section N is exclusively for billboards. So, and yet you make a reference to freestanding signs, which I'll get to in a second why that's problematic, but it's in the billboard section. So do you mean any sign that referenced the infamous May 19th, 2008 should have that language? Because we can do that. It already exists in the red line in terms of portable signs. We can add that to, and I have language, to revise the billboards.
Yeah.
But I just want to make sure I understand what you're aiming at.
Okay, Madam Chair and Commissioner Baldwin, subsection N has been modified and I think maybe circulated very late. So all subsection N says of subsection 0.3, these are prohibited signs and they say billboard, nothing else. Okay, those two subsections were removed. So a billboard is an illegal sign, so to speak.
Right.
Okay, so you couldn't do a new one, whatever. In subsection K of 9.2.22.2, then the exception that covers what we've talking about was reinserted in as far as exempt signs, and that talks about signs that were in existence as of that date, or those that were previously approved and licensed by the village. So that's the only new change, is put the exemption in subsection K of subsection 2 and remove the subparagraphs in subsection N.
So again, working off the red line, the general sign regulations, which is where the exemption piece in K exists, is 9.2.22.1, not 0.3, and prohibited is 9.2.22.2. So my concern in adding language that says legal signs, including otherwise non-conforming signs that have been previously permitted by the village, to the writ large exemption for all signs in the village is, for example, someone could have properly gotten permitted a temporary sign that was supposed to expire in 90 days, this language would indicate to me that they would get that free ride because at one point it had been legally permitted. And so while I'm not happy about, eliminating an amortization, I mean, good God, Lady Bird Johnson's rolling over in her grave about not being able to remove billboards. And again, we're not talking freestanding signs that are attached, a part of the property, like the Great Ridge 66 hotel signs and diner signs. That is not what's being talked about, which is why using the term freestanding permitted signs would include all of that based on our definitions. And so I think there is a way to address what you're looking for, I think. There are 3 sections that reference or address the issue that you're talking about. Subsections are all on prohibited. E, which is portable signs, and it specifically says, existing at the time of May 19th, 2008, are allowed as nonconforming signs only as long as the sign remains on the original premise and is not relocated or replaced. That's the change thing. That is what we redlined. That's what we approved on April 8th. We can take that same, are allowed as nonconforming signs, existing as of May 19th, for I, which is off-premises signs. Again, they're not the same as billboards, but they sort of wear the same color. And also in N, which is billboards. Those are the 3 places that specifically refer to that March 19th, 2008, where we can say, if you were approved by that point, you get to live out your full life without just compensation or being required to take down. We can say that. But having a blanket exemption for any legal sign that was at one point previously permitted in the village basically would imply that we don't make any changes to anything. I mean, that just doesn't make sense. Again, I'm thinking about a temporary sign that had an expiration date.
Are you looking at the red line that was circulated today?
I'm looking at the red line that was circulated and posted on the website, which is what we approved on April 8th. I did look at the one that you sent, which unfortunately doesn't include a lot of those revisions. And so I would rather amend what we approved on April 8th to address the most specific issues that you're talking about, which is apparently we don't want to be on the hook for paying just compensation at the point of an amortization period being over. Is that correct?
There is no amortization anywhere in the ordinance at this point.
We need to remove the 2008 date. It means, other than to say it's a point in time prior to which you are non-conforming. But I agree, we've got 2011, which is confusing, we've got 2008, which is confusing, and apparently 2003, when this first got started. And so what we're trying to do, I think, is get clear so that anybody who has a sign or is looking at acquiring a sign knows what the rules of the road are for applying, and that we can have a reasonably enforceable sign code, which is key, right? I mean, part of this challenge has been, it appears that there wasn't a lot of communication or a lot of enforcement of things that had been in the sign code, illuminated signs. I mean, that's been like in their, like, old-timey as prohibited, but it's not like that is something that has been enforced throughout the village. So I think there's work to be done, but I do think that there is a way to address all the instances that stated that May 19th, 2008 is that dividing line that you're talking about.
That is the dividing line we're talking about because it was in the old ordinance in 2 different ways. And the one that exempts it from this section and allows them to exist is the correct interpretation. Now, but we run into the same problem if a sign has been permitted. Now, the statute I'm talking about does not cover an illegal sign. It doesn't cover that. But there are signs, for instance, that have a term to them. They have a term. And so when that term is up, they expire the permit, whatever, then they could be required to be removed and there's no compensation because that was the permit. If a sign was permitted and has not substantially changed, it comes within the context of the statute to say requiring removal would require payment of just compensation. So what we're trying to do is say anything on a go-forward basis has to meet all of these criteria. If something was approved prior to that, we are not requiring them to be changed because we do not want to have to pay for it, frankly.
Right. I understand that, and I believe that I have worked up a motion to address that within the red line, blue line, green line that we all approved on April 8th. So when we get to making motion times, we're now in the conversation time, I'm happy to do that.
Okay. Further questions or comments?
I have a question,
Commissioner Tagliapetra.
Mr. Chapel. Okay, so I'm getting a little confused on what we're going to do with, if it's here and it's approved or whatever. On signage, here it's under C, it says electronic message boards with moving messages are under prohibited signs. We have one in the village. So would this sign then become approved? If we go back to this 2008 whatever, or whatever day we're going to throw in here?
Madam Chair and Commissioner, what sign are you referring to?
Kelly Joe's,
Kelly Joe's?
electronic sign with flashing,
Was that sign permitted
I don't know.
in that context? If it was permitted, we have to allow it to exist. If it was not permitted in that context, then it doesn't get any benefit of this exemption or whatever, and you can require that it be comply with the code.
I guess I would want to know how it was permitted since it's a forbidden sign.
Yeah, and I have no idea how it was permitted, but it applies to signs that were permitted by the village, and that's the process of getting a permit, or those that were in existence as of 2008. Okay, so that's the exemption, the blanket exemption. And I think that's what we need in order to assure that if you want somebody to take it down, then you don't have to pay for it under that statute.
Mr. Williams, could you find out about Kelly Joe's sign, please, sir?
Madam Chair, Commissioner Tagliapetra, do you know or can you guesstimate when that sign was erected? When did it go up?
It's gone up since I've lived in the village, and I moved here in 2013.
So to answer your question,
I don't think it's been very long.
They're saying, but I just know it's after I've moved here.
so to add another layer that will hopefully answer your question, I suspect, I mean, yes, ma'am, we can certainly look at it, have our enforcement officer take a look at that, but I suspect that if it's been permitted within the last 4 or 5 years, the existing sign regulations do not allow electronic message boards with moving messages. So if it was permitted with that restriction, and it's an enforcement action to notify the sign operator that while they can have an electronic sign, the moving messages are what's prohibited, and it becomes an enforcement action. It wouldn't grant them any sort of right to not comply with the standard.
Okay, thank you. I just wanted to make sure that throughout all of these revisions of this and revisions of that, that we weren't permitting something that was not really supposed to be there.
Madam Chair, Commissioner, understood, and again, in order to be non-conforming, it needs to be legal. It's got to be permitted, it's got to meet size, location, all of the applicable standards based on the rules that were in effect when it came through the process. And again, I suspect that we've got an electronic, we dealt with them in Albuquerque quite frequently. They get a permit, we write on the permit that you can't have messages that change quicker than every 7 seconds or whatever the standard is, and a property owner gets a hold of the sign and they tweak it, and suddenly it becomes out of compliance. It's simply a matter of notifying them what the standards are, what restrictions they're held to, and ensuring that that action takes place.
Okay, thank you.
Madam Chair, if I could follow up with Commissioner Baldwin. The red line that was circulated with the packet, with that one exception, is not the same document as I indicated at the April 8th meeting that was attached and discussed at that meeting. One of the things that we did was, because of the constitutional issues, we were authorized to have another law firm, municipal lawyers and so forth, check it, verify these different kinds of things. And so their comments have been adopted. For instance, there was concerns about establishing commercial and non-commercial signs as being content-based. So there have been a number of changes in the document that was published from what was reviewed on April the 8th. And so I think that is the document that we need to deal with.
I'm sorry, Attorney Chappell, but nothing that has been properly posted, nothing that has been properly discussed, and not inadequate time to even read it is not cool. So I don't know what we have. I mean, we have two choices. You can either explain the specific changes that they believe were content-based, and we can make those revisions in public now and have that conversation, or we're going to have a continuance so that we can actually read the stuff that you're saying and provide and ask more questions. Okay. Because we put, I mean, again, this isn't last week. This is April 8th, when we spent hours going through this discussion and working through the issues and trying to be very specific about that, including, that there is language already in there on portable signs that specifically says, existing at the time of May 19th, 2008 are allowed as non-conforming signs only as long as the sign remains on the original premise and not relocated or replaced. And that would be the language I would suggest, striking the all existing billboards and portable signs will be removed language, by March 31st, 2011, and then saying all existing billboards and portable signs in existence at the time of May 19th, 2008 are allowed as non-conforming signs only as long as they are not relocated or replaced. That seems to address the instances where that line was drawn in a way that doesn't create other problems. Freestanding signs also include signs that are attached to businesses. And they don't have restrictions. We don't want to give the impression that somehow they had restrictions or they have restrictions as of May 19th, 2008. So we want to be specific to billboards and portable signs because those are the ones that specifically talked about the amortization period, correct?
Yeah, Madam Chair and Commissioner Baldwin, all I can say about that, when you got the package, the package that you got for the meeting is substantially correct with those two exceptions. And all I can say about the time and whatever, as I pointed out on more than one occasion in the April 8th meeting, the document was being reviewed by outside counsel and we would be submitting a new form of resolution. I think our ordinance. I think you should have all of the time that you would like to review it and make your comments. And so the timeline is not something that I am pressing. There's not a press on it. So you should have the ability to do that. But the one that was submitted with your package with those two exceptions are those that have been, I've been through and outside counsel has been through and is something that we think is supportable both constitutionally and enforceable. Doesn't mean that it's perfect.
So I need to ask the question again. What we reviewed was what was referred to as the red line, blue line, green line. Is that what you are referring to with the exception of this amortization language clarification around May 19th, 2008? Or are there other changes that are not included in what we were sent and what we have reviewed?
There are multiple changes, Commissioner, from that document that was in front of you on April the 8th, throughout the document.
Okay.
I guess my question here is the vote tonight time sensitive? If it isn't time sensitive, I think that we need to have a discussion about basically getting down to the basis. If you feel that it carries that much of a merit and it isn't time sensitive, because if it's time sensitive, we could try to work on it right now. But if it isn't time sensitive, I think that it may take longer than we can expect, and would agree with her that if we need to.
Yeah, Madam Chair and Commissioner Martinez, here is the time sensitivity. Once the constitutional issues were identified, then it puts the village in a position that portions of the ordinance may or may not be enforceable when people come in. So we need to get it done, but there's not a specific deadline in terms of that occurring. But I do believe as council and that your input's important. And like I say, we received a great deal of input after the April 8th meeting, and that has been incorporated from, like I say, outside counsel also. And so you should have a chance to review that.
All right. Thank you, Mr. Chappell. Before we go further, because I see where this is going, let's go ahead and we've got several people that have signed up to talk on this, make comments on this section. So I don't see Ron Chavez in our audience. Is he perhaps, Darnell, online? No. Okay. Cal Chappell? Cale? Please, if you will approach, give your name and address, please, and you'll be given 3 minutes.
My name is, hello, my name's Cale Chappell.
Hold on, it's not on.
Oh, it's not on?
I bet you she turned it off when she was.
There's a light, there's a red light on it.
Oh, yeah.
Hello, my name's Cale Chappell, and I don't think we're of any relation with Mr. Chappell there, but spelled.
Can I ask you to hold on just one
Yes.
brief minute? Do we need to swear these folks in? I didn't think so, because it's,
Legislative.
we do not. Okay, I'm so sorry
No.
to have interrupted, but that was procedural that I needed to know.
No.
If you will continue, please.
That's absolutely fine.
We
I'm,
do need to. Do we need to swear them in on that?
Because this is purely legislative, I did not think it was necessary to swear them in. If you would like, I can, but it's not a quasi judicial type hearing.
Right.
So I don't think it's
I don't
necessary.
think we need it then. Thank you for confirming, Mr. Chappell. And Mr. Chappell.
Mr. Chappell. Mr.
If you
Chappell?
will start all over again.
My name is Cale Chappell. I'm a homeowner and resident here in the village at 6435 El Caminito de Guadalupe Road Northwest, maybe the longest address in the village. And I'm also a commercial property owner and business operator here in the village at 6463 4th Street Northwest, which is now Fiber Arts on 4th. So first, I apologize for my ignorance, but I got this letter, which is what brought me in tonight, because I saw, of course, my address is in this proposed zone change here from Village Center to Core Commercial. And I don't really understand what the difference is between the old zoning and the new zoning.
Is this on tonight's meeting, or is this actually next week's meeting? You're shaking your
Madam
head
Chair,
no.
it's not on tonight's agenda.
Oh, I'm just following the letter, says June 10th.
I haven't seen the letter, so I don't know.
I will not be,
Go ahead and continue.
yeah, I
I'm so
won't be
sorry for
available
interrupting
next
so many times.
week. Sorry. So I just wanted to come in because I have a proposal, or whatever you call it, a permit application pending. I've been working with an architect, mechanical engineering for almost a year to do a remodel, primarily interior remodel of the facility. at 6463 4th Street. So my main reason for coming tonight was trying to find out, like, does the proposed zoning change affect my proposal and permit application? It's been in the office there for several weeks, and I was trying to come to learn more about that.
So, Mr. Chappell, if I understand correctly, because I thought maybe it was the other Guadalupe Trail, which is on the 24th, but you're talking about the Village Center zone revisions to create potential commercial center zone, correct?
Yes, changing from the Village Center, which is when I purchased the property about a year ago, it was Village Center zoning, and now the proposal is to change it to core commercial on one side of the street, but not the other side of the street.
So I believe that is on our July agenda at this point. But Mr. Williams, can you provide any illumination on that timing?
Madam Chair, Commissioner Baldwin, absolutely. Thank you for the opportunity. Yes, this matter was originally noticed for the hearing tonight. We had some additional steps that needed to take place. So it is planned, scheduled to be heard before this body in July, at your July regularly scheduled meeting. Mailouts will go out again. We will run another legal advertisement announcing this. And as always, the village is available to answer questions, I believe the mailout provided a copy of the proposed regulations, but we could also answer questions 8 to 5 Monday through Friday or through an email if there are specific, what will this do to my property or my project type of issues.
Excellent. I will make an appointment to do that. Since I'm standing up here and I have the microphone, I will submit my support for having an updated signage code, and that everybody should come and apply for permits like I did for my business and conform with the codes and have some enforcement so that we have that consistency throughout the village. So maybe that's why I came tonight. Thank you for your time.
Thank you for
Thank you.
coming. Thank you. Sorry for the confusion. Okay, next up, Mr. Sanchez.
Hi, Vincent Sanchez, 6802 Rio Grande. I used build to line last month as an example of a removed definition. This was a useful definition that could help people or the village define where structures can be built to. I also expressed concerns that a temporary consultant is advising alterations that remove parts of village code. I admire commissioners that are hesitant to make changes without thorough discussion. Before, the term more robust was used as a qualifier for replacing one item for another or for elimination. Well, I have an example of that more robust section of code. Like build to line, they are useful to me and with issues concerning me and my family. Section 9.2.7, A1 agricultural residential zone, 1 acre or others. Section E, area regulations. 2, setback limits apply to all buildings, structures, including swimming pools. 3, setbacks shall be 25 feet. 4, for any property bounded by an irrigation ditch or drain, that setback shall be 25 feet. So that's the residential code. The more robust is the commercial code, 9.2.12 C1 retail commercial zone. And it states, for any property adjoining an MRGCD maintained irrigation ditch or drain, the minimum setback along that ditch shall be 25 feet from the nearest bank edge of the ditch or property line, whichever is greater. The question is, will the more robust version be adopted? In my experience with the village, I've been shown negative to dismissive views on acequias and Los Ranchos. Changing just slightly. This goes to the sandwich board. At one point in the village wanted to standardize sandwich boards to something that was basically just more aesthetically pleasing. They didn't want to have plastic signboards. If you are curious about this wood signboard that met the code at the time, I can bring you a production version if you'd like to see it. And that's pretty much it.
Thank you.
Thank you.
Okay. So to continue then, are there further comments or discussion on our TA 25-01? Commissioner Edward?
How are you?
Good.
So one of the things I was thinking about in all of this is how and when will this all be enforced, and how can it be effectively and efficiently enforced? And has there been any thought given to how many signs currently are even meeting the guidelines? Because I think that when we have enforcement rules and laws and things that we change, the question is, is there a reasonableness that they're written in such a way that they can be monitored and enforced? And I say that out loud to everybody here because if there are many countries that are far more lax in the way they treat certain things, but if you look at their laws, they're far more restrictive than they are in the United States. And so the fact that we haven't had a code enforcement officer for so long, and then when we have had one, and then finding out things that were not enforced, I have a concern as to how do we simplify this and make it easily apparent to the citizen as well as the inspector that something's out of whack. Because otherwise, nothing will change and people will just violate the rules. And a good example of this, if you're a realtor in the village of Los Ranchos, you're required to get a permit. And you hang the permit on the sign. Now, I haven't looked lately at many of the signs around the village, but I don't see any other signs, to my recollection, that have any permit hanging from them to notify anybody that that's actually a permitted sign. And it's kind of effective. And I believe that fine young lady in the back of the room there told me that the permit on the realtor sign was to ensure that we collected the gross receipts relating to that transaction for the village's benefit. And so I'm not sure, Mr. Williams and Mr. Chappell, how that was considered in this policy. And you've seen other policies in other municipalities because you've worked in other municipalities, but do we have a realistic chance that this is going to be, these things are going to be enforced, if not enforceable? Do we have any idea, like right now, if we passed what was there, how many violations would get handed out? I'm just kind of curious where we are in all of this. Have we handed out violations on signs even before?
Madam Chair and Commissioner Edward, if you're directing that at me, I don't have any really thing to do with enforcement. We have not modified the enforcement provisions of the sign ordinance. That is as it has been. That is not something that we were tasked with to do that. So that's a purely administrative function, and I've not been involved in that whatsoever. And so I can't respond to that. Obviously, every time we do something in the village, we have the questions about enforcement, and I think the village may be making progress, but that's all I know about it.
Okay. Brennan, do you have any ideas or thoughts on that topic?
Madam Chair, Commissioner Edward, I also am not involved in the enforcement aspect of that. At least it pertains to village work. But I would add that enforcement occurs in any number of ways. Those are efforts that are made to achieve compliance. So just because it appears that compliance is not being achieved doesn't mean that enforcement action isn't taking place. Standards that are in effect can, if they're adopted legally and correctly through the process, can be enforced. As I've mentioned to this commission multiple times, if you perceive that there is a code violation, the best thing to do is to notify the Planning and Zoning Department, and all we need is an address, and the enforcement officer can go out and take a look at the issue.
Right. One of the things that I thought of, if we're evaluating this, the more I thought about it, basically there's so much text there, I think that somebody who was going to go look and research to see if they have the right kind of sign, they'll stop doing it. They'll say that this is a joke. I'm just going to go out and put one up. And I think in today's world, you know, with computers the way we use them, I mean, rarely do you ever see people who go to a meeting anymore without a laptop on their desk or something, even their phone. I think there should be, if possible, a simple 2 or 3 pages of visual examples. This is permitted, this is not permitted, this is permitted, this is not permitted. Examples that people can quickly go and without having to read a bunch of legal jargon, what looks to be that's clearly not sagacious or appropriate under the circumstances. I don't know how you guys feel about that, but
Certainly, we couldn't capture every don't do this version.
right, yeah, but here are the top 10 things. that we-
Exactly, the most frequently used mistakes or illegal signs. That would be a very good demonstration, yeah.
I mean,
And that would be an administrative, it wouldn't be in the code itself, right?
No,
no, I think it would be in the code. It could reference this image. Here is an example of this meeting a criteria. Here's an example of it not. It's basically a way to annotate with pictures the code itself.
The code is a legal document, so we kind of have to have the legal pieces to it, but I do think, just like when we did with the conservation district, that there were, not in the code, but examples that
Right.
I think staff have created to say, here's how a calculation would work, or here's sort of examples that will be handed to people who come in saying, I'm interested in making, use of this. So that makes tons of sense to me. I think it's tricky to put those specific examples into code.
Well, somewhere it needs to be placed. We also have a high rate of illiteracy in the state. And to the degree that somebody can go by something on a visual basis, I don't know, that was just something I was thinking about. And then the question I have is, this idea of whether we pass today, we don't pass today, how easy is it to amend anything that we would do? So there's this question as to whether we're going to do something now, next week. Do we need to discuss it further? How easy is it to amend anything that we would put our rubber stamp on?
well, it does, yes, it is a question.
Yeah. Madam Chair and Mr. Edward, what you do at this level are not drafting ordinances, but you make recommendations to the Board of Trustees. And this will go after your recommendations will go to the Board of Trustees, and the Board of Trustees will accept that draft or make additional changes or whatever between the time this happens and they approve it. When it goes to the Board of Trustees, since it is an amendment to the ordinance, their first action will be to adopt a resolution that permits it to be published. And it will be published and then come back before the Board of Trustees the next time, and changes can be made based upon comments and questions that come up during the time it was authorized to be published and then adopted after the publication. So that's kind of the process, if that's what you're looking for.
So if that's the case, are our findings or concerns as a body at this stage of the game as critical as we think they are?
Madam Chair and Commissioner Edward, that is part of the delegated duties under the statute in land planning type things for this body to review and provide recommendations to the Board of Trustees.
Which they don't have to follow.
Which they do not have to follow, But on the other hand, this body tends to be the more technical review than it's at the board level. So I think it's very important personally, and I'm just speaking as an outside contractor, I think it's very important to have all of the input that we can get before it goes to the board so that those questions are answered correctly when you get to the Board of Trustees.
So, Mr. Chappell, let me ask you a question, and I'm kind of going back into what we had before. Those additional updates over and above our reflections from our last review of this document, those were only done in the sign ordinance portion, or were they also done in other pieces of this?
The only thing that has changed from that is the actual sign ordinance itself. None of the other stuff that you did, moved around and so forth, has been changed. We did look at one definition that's back in this draft of the sign ordinance. Commissioner Baldwin thought that when you described a temporary sign, that it ought to have a specific date. But under the text of the ordinance, a temporary sign is something that's not permanent. But there are different provisions of the ordinance that can assign how much time is allotted to a licensee. And so therefore, that definition, we didn't change that because we think it's 90 days doesn't fit every single temporary sign because some are allowed for this period of time, some are allowed for this period of time under different provisions of the ordinance. So some of those things got incorporated. I don't know we had a complete transcript. A lot of the constitutional and other amendments were not discussed the last time around, but none of the other adoptions that were in the discussion on the 8th changed in what has been submitted here.
Thank you very much. So let me go back.
One thing I'd like to make a comment about that, what we really need to recognize also is that the changes that were made from them, the reason that they did it, we have to understand that reason. And that reason, as he's describing about, is a legal precedence that we need to recognize. It'd be easy if we could just, as you're defining, to do it. But what happens when the wealthy person comes in, he brings his lawyers and brings a lawsuit, it boils down to what did we put in that they reviewed that gives the village the placement to be on the right side. And I think that's what they did on this changes that they made, that something came to their attention through another attorney's office that has to do with a higher, whether it was a lawsuit or something for signage, that gives us a better understanding of how to change the language in there. And I think that's what we have to keep in mind here also.
Great, thank you.
That's my only comment.
Well, it sounds like we're in hot water one way or the other. If we don't pass something, we're in hot water, and if we pass something that's inadequate, we're in hot water. So what's the better hot water to be in?
No, I disagree with that comment, but,
That's right, I have a question.
okay, you've got a quick question.
Quick question. The agenda for June 17th, the special meeting, is currently focused on quasi-judicial issues, not legislative issues, which is the reason for the separation between today's agenda and next week's agenda. If we are to entertain a motion to continue, we have to do it to a date specific. So I want to get a sense of whether there would be a preference for June 17th or July 8th. Which is the next regularly scheduled P&Z meeting,
Mr. Williams?
from a staff perspective.
Madam Chair, Commissioner Baldwin, thank you. My recommendation would be that it be deferred to the meeting in July. I'm worried about noticing requirements. I don't think we have enough time to do that. And then again, while I work for the village administrator, this is not the only village administrator I work for. So my ability to have time to be able to work on something like that, I believe should be a determining factor in your decision. The more time, the better. Again, this commission needs to be comfortable in reviewing the materials, having enough time to go over them, and then having the opportunity to bring it back for discussion.
Thank you.
Okay. So if I may continue down the path I'm trying to narrow down where our focus is. So commissioners, I want to ask, are there any concerns, comments that we need to address from section 9.2.3 definitions? Did anybody have anything on that? Okay, seeing and hearing none. Did anybody have any issues with 9.2.6 transfer of development rights regulations? Okay, continuing, 9.2.13 gateway district zone. No. 9.2.14 village center zone.
Yes.
Yes, okay. Commissioner Haywood, let's go to your concerns.
It's not a concern, it's just a question or clarification.
Okay?
On page 48,
Page 48.
Hold on, give us a second.
Give us a second to get
Give
there.
us a second. 48.
document?
yeah,
Of
Of the attachment.
right. So it's 9.2.14, VC, Village Center Zone.
Hold on, hold on. Still,
page 48 of that.
yeah, I'm trying to get to it. Hold on.
Which is what page of it?
Golly, I have no idea.
Yeah, okay, you're gonna have to go,
Okay. Is everybody to page 48 now?
Well, I'm on page 48, but I'm not seeing what she's saying.
Okay, what
It says
specifically on,
attachment 1, page 48. My question is to Mr. Williams.
and where, tell us where you're looking so we can. be on-
So it's, section 9.2.14 VC, Village Center Zone.
Yes,
Starts off with
There it
purpose and intent, and then goes A, location and area, B, economic development plan, and then there's subparts of that. Mr. Williams, aren't site development plans required for any commercial development?
Madam Chair, Commissioner Haywood, yes, ma'am.
So, to me, there's a discrepancy then, because it says in Part B, economic development plan, an economic development plan may be required for any development within the VC project area. But then subsection A says, site development plans for the project area shall have an economic development plan included. And it sounds really nitpicky, but may in our definitions is permissive and shall is mandatory. So if I'm reading that correctly, that is a conflicting statement.
Madam Chair, Commissioner Haywood, I guess I would agree with you. Again, the blue text was discussed at the April meeting, and this is coming out of the definition section. It was felt that it was more appropriate to be placed or to be removed out of section 3 and placed in section 14 here. Certainly, if you have a suggestion or an edit, we can incorporate that.
I suppose my question would be, if this is content for the VC zone and we will be seeing that in July, this may be a moot point because we can address it then. Or, right, if it's going to be up in July, then this is somewhat of a moot point, right? Concern of permissive versus mandatory. Am I addressing this at the wrong meeting, I guess would be my question.
Madam Chair, Commissioner Haywood, I'm not sure. We can certainly, if you'd like, we can certainly ensure that it's addressed when the changes, the upcoming changes to the VC zone are formally introduced. If that would suffice, again, I can put a pin in it and we can iron it out at that point in the future.
Okay.
okay, so it will be readdressed in our July meeting
Yes.
when we review this. Thank you. Does anybody else have anything on that particular item? No, okay. So, what was the next one?
Signs.
Signs.
Okay, and then the last, that's the biggie,
We're back to
that's the
signs.
monster. Okay, we know we've got issues with signs. Was there anything after signs? Sorry, guys, I'm scrolling at this point.
No, I mean, just the usual language that say, with the staff findings.
Okay. So. Give me just a moment to get back up where I was.
Permits are after signs.
Permits, okay.
Permits are after signs.
So how about the permits then? So,
Permits is on page
Minutes.
64.
hold on. No, how about 9.2.18 off-street parking regulations? Did anybody have anything on that?
That's not a part of TA
Oh, gosh,
2501.
I jumped to a different date. Okay, sorry. TA 28, yeah.
So,
It's on the header as one of the items that we were addressing.
I'm looking at the department recommendations and findings.
Yeah, I'm looking here on our header. That's what I was
Looking at the
going
staff
through.
report, okay.
Yeah, so this is the header. We did the village center zone. Then the next one was 9.2.18 off-street parking regulations.
It's not in the list.
It's
don't
just
bel-
signs is it, signs is the last.
Yeah,
No,
I
there's
hear
permit-
you,
There's permits.
but that's the
On
next
page
thing that's on
64,
there.
there's permits.
Was 9.2.18 not included in our packet?
We
Okay,
didn't
so,
deal with it in the 8th of
so
April.
we need to see that update on that, please, for our July meeting. That or have this header, the TA 25-01 header corrected. And then it's signs, so,
And permits. Permits is still here too, page 64.
and that's interesting, because permits
Page
are not on the
64.
header.
Hang on, I go to the red line.
Maybe I'm June 10th.
Yeah, that's why I'm concerned.
No, that's a fair thing. I think it's where things were moved from one section, so they would all be in the appropriate definitions, but that is,
Do you see page 64?
I do, it's there.
Okay, just as long as I'm not going crazy.
Yeah.
And then there's even
Oh,
one.
yeah. It is there, and it is speaking to permits for signs. So you're right, it is a separate section that isn't referred to in the recommendations and findings, but it was attached to signs, so it is a part of the red line, blue line, green line document.
Okay. So we've got that then, okay. And then the last one was the signs, which we know we've got a whole issue with.
We've got signs and signs and signs and signs and
Right.
legally and sign permits.
So it looks like the majority of our discussion, yes?
But that's why, it's 9.2.22, and all those things that we've talked about are within that.
Right.
So it's not broken out. So
Okay.
that's why I think it's listed that way in the recommendation.
Okay, in the header in that, okay, gotcha. Well, that makes sense then. So I guess what it boils down to, aside from Commissioner Haywood's comment that we need to look into, it looks like our focus will continue to be on signs. We have quite the discussion and need for us to really go back and take a look. Because I know personally myself, I am now really questioning what did I not see that may have been updated. So I would entertain a motion.
I have actually two motions. One is I move recommending approval of the portions of TA-25-01, including the changes made and approved by the Planning and Zoning Commission at the April 8th meeting to amend the text of 9.2.3 definitions, 9.2.6 transfer of development regulations, 9.2.13 gateway district zone, 9.2.14 village center zone,
That's,
with the related staff findings, so that we can get that done. And then I will make another motion about continuance of the sign section.
I'll second it.
okay, it's been moved and seconded for adoption with those caveats. Is there discussion? I will make a comment. I personally would rather this come back as a whole unit before us, because I'm concerned at this point what we haven't perhaps seen. Yes, we could piecemeal this out, but I don't think, my own personal opinion is I would prefer to wait for the whole package. I want to make sure that we've got an answer for the question that Commissioner Haywood had with the apparent or perceived inconsistency with that language that you brought up. So with that, is there anybody else that has a comment?
I mean, I'm happy to defer to the chair's desires. I'm also mindful of trying to move along stuff where there isn't controversy. But since I don't think any of us have actually read what was sent to us this afternoon, you know, in an abundance of caution, I'm fine doing a continuance motion for the whole Megillah.
So you would have to withdraw your motion?
I shall.
And I shall.
Okay, so
Then-
motion has been removed.
It has.
Withdrawn.
It has withdrawn. However, I have another motion. I move continuance of TA-25-01 until the July 8th regular P and Z meeting for consideration of amending the text of 9.2.3 definitions, 9.2.6 transfer of development right regulations, 9.2.13 Gateway District Zone, 9.2.14 Village Center Zone, and 9.2.22 Signs of the Comprehensive Zoning Code to remove duplicate and unused items, modify existing formatting for consistency and clarification, and updating all standards to meet applicable specifications and requirements with the staff findings. And I would like to encourage one additional finding, which would be, in order to make meaningful progress on conformance to the sign code, the Planning and Zoning Commission and the Board of Trustees shall be provided with semi-annual updates on non-conforming signs, communication with non-conforming sign owners, and enforcement of the sign code. This work is a crucial part of effective engagement, enforcement, and code compliance.
Okay.
So that is the motion.
Is there a second?
I second.
Okay. Any further comments or questions regarding the motion?
I guess, you know, again, I think that the findings are important to put into the mix because we keep having the circular conversation, but I'd be really interested in hearing if folks have strong objections.
Okay, this is a roll call vote. Commissioner Edward,
Yes.
Commissioner Baldwin,
Yes.
Commissioner Tagliapetra,
Yes.
Commissioner Martinez.
Yes.
Commissioner Haywood.
Yes.
Commissioner Homan, yes. So we will revisit this pack with a few additions that we've requested in our July meeting. Okay. Let's see, we go on to old business, which there is none, new business, which there is none, and reports now from the Planning and Zoning Department. Mr. Williams.
Madam Chair, thank you. Not a report per se, but was just going to mention what was discussed earlier. The changes to the VC zone as well as creation of what we're calling the CC zone was originally anticipated to be heard tonight. One of the reasons, I believe as Commissioner Baldwin mentioned, that we have, and I appreciate the Commission's indulgence, that we have a meeting tonight and then we have a meeting next Tuesday night, is we were trying to separate, anticipating a very long meeting tonight. We originally had the changes to the code coming back before you, as we just discussed, as well as this proposal for changes to the VC zone and a proposal for the CC zone. As I mentioned earlier, we did send notice out to the affected property owners. We did run a legal advertisement, but realized as we were getting our ducks in a row for tonight, to schedule for tonight, that some additional outreach needs to take place. And so that is going to be done. As I mentioned, we're going to re-notify everybody that received initial notice that this matter would be discussed, or at least start the discussion tonight. That will occur in July. So I just wanted, I know that several of the commissioners as well as members of the public are interested in that, so I just wanted to clarify that notice, advertisement, where staff's available to answer questions that may come up as it relates to that. But that process to advertise the upcoming discussion in July will continue to occur, and you should see that, hear that next month at the July meeting.
Mr. Williams and Mr. Avila, I would request that, since we're deferring, well, we're deferring. Continuing in July. When that does appear on our July agenda, can we make sure it shows up as old business so that we're allowing the public that may be here for a specific variance request or whatever their specific item for our hearing, it would allow them the ability to have their items heard without sitting through a very long, potentially long discussion, just respectfully. Thank you. All right. So that, thank you for your report. That pushes us now into commissioners' discussion. Commissioner Haywood, let's start with you tonight.
There seems to be an ongoing issue around dogs not being on leashes, and it's becoming more and more confrontational. So I've heard various interactions between people, and they're getting more and more hostile and more aggressive. And when contacting the police, they say it's a animal control issue, which in theory it is, but the problem is that when it becomes hostile interactions between people, it's no longer about the dog being on a leash, it's about confrontation between individuals. So I just wanted to bring it up as a potential escalating issue in the village of people not having their dogs on leads, and then people confronting these others, and then just very hostile interactions, because I'm seeing it more and more.
Is there any particular place you're seeing
On the
it?
ditches.
On the ditches,
Yeah,
okay.
absolutely. And probably in parks, but because I live next to a ditch, I hear it a lot. And then I'm also, because people know I'm on the commission, they start telling me their stories. And even the stories have escalated from, I shouted at somebody on the ditch, to I'm now waiting for them to pass by. I know what they look like. So it's becoming basically a public safety issue.
Thank you. Thank you. Anything else?
Something some other people keep on bringing up because I'm on the commission is, are there any plans to upgrade the tennis courts anytime soon?
Now I have sound. There's the overall tennis courts, there isn't that in the budget right now. There is some small upgrades that are, getting benches, making sure that it's cleaned up, but there isn't a budgeted amount at this point for, say, repaving and resetting the tennis court material. So at this point, that's not there. We do have a budget coming up, so we're not finalized yet. But it's something that has been, kind of on the, we need to do it to see how, because it's going to be expensive. So that's the other part that I understand is that, it's going to have to be a substantial budget item.
Commissioner Edward.
I think the tennis courts look pretty good. It's the bathrooms they're atrocious. I have a tennis court. But no, I think the bathrooms there are bad, but that's not a planning and zoning thing. I put this out before. I'd like some way to honor people who take care of their properties. We give out architectural awards for, in our community at large, Albuquerque and stuff, for new projects. But we don't say like, hey, man, this is a 30-year-old project and it looks great still. I mean, there's a lot of things that start out nice and then they turn into mush. And I think that the project at the corner of Ranchitos and 4th Street where the antique mall is, man, that thing is an eyesore. It's one of the biggest commercial properties in the city in the village of Los Ranchos. That thing just looks awful all the time, man. No landscaping, the landscaping isn't maintained if there is any landscaping. I mean, that's like a major intersection where people stop in our community and they got nothing to do but to look around until the light changes and they see really unattractive. Pride of ownership is not there. I mean, the broker's sign is falling apart. And nothing gets done about this stuff. The watermark on our tank is way too low. So, hey, maybe they get a year's property tax abatement if you win the award for having the nicest maintained property. That's a big shot in the arm for a lot of people. That might be $7,000, $10,000, $25,000. Maybe that'll get people to do something about maintaining their properties, because we don't have a code enforcement guy, and he's probably stretched thin when he is here. So let's give out an award.
I know it was mentioned, I think by Commissioner Tagliapetra last month, that same shopping center. I did reach out to Rick Saylor, the owner, and he was aghast, saying, "We've always maintained that landscape right."
That's
I said,
insulting.
I know, and I told him, said, "Rick, you need to go back and take a look at what the situation is now." I told him that the weeds were growing. Pardon. And at least they went through and mowed. But his attention was directed to it.
You okay?
Excuse me. I hate allergy season, and I was gardening all morning.
And where some of this comes about is that the village is spending, what was the figure? $10 million beautifying 4th Street. For what? So that people can continue to make their properties look bad?
Yes, I agree. But that's just a demonstration, my comment was a demonstration of how out of touch some of our property owners are. So, but this is where we really need to bring up some of these issues, and I appreciate that feedback.
I have friends that lived in other parts of the country, and if their places don't meet the landscaping standards, they're fined at the billable rate of the landscaping company that comes in and does it at the assessment of the municipality, and it becomes a lienable item. And for some of these places, they have to mow their grass twice a week. Can you imagine that? Twice a week. And it turns out to real money. And we talk about wealth, and do we have wealth as a village? We do, but to the extent that it could be better than that, just because we take care of our stuff.
Thank you. Commissioner Tagliapetra.
I don't really have much, but I do have a quick question. Did the guy that owns the antique shop get permission for his liquor license? Through the village?
No way. Liquor license? He's selling liquor?
It's gonna be a wine
Oh,
bistro. It's gonna be wine and tapas.
they're at the,
Where the antique, that old farmhouse,
oh, okay.
that old farmhouse is supposed to be wine and tapas. Did he receive his liquor license?
Do we have an address?
Oh, God.
It's gotta
It
be.
was like the old Chavez grocer, or
It's,
7,500 block, 7,600 block.
God, I'm not gonna.
There
on the
was
west side of
and this is me just answering based on,
So one in north
my-
of the Los Ranchos Elementary on that.
there was a Victorian type home
That's one
that had
historic.
come before Board of Trustees and had been reviewed, and I believe, we have to go back and check the record.
I believe it went through the Board of Trustees as far as a review. So I couldn't tell you the.
I thought
I'm
they
not gonna-
denied it, though. I
I'm not
thought they
gonna,
denied it.
yeah, I'm not
Yeah.
gonna comment on what the result was, because I just can't recall, but I know it did go that far.
Okay, thank you.
Interesting. Commissioner Baldwin.
Oh, I think I've made my views for this evening well known.
Commissioner Martinez.
I continue saying that every time we get here and every time I see you guys raise up with the way you guys are, I think that we're blessed to have what you guys and we all come to put to this planning and zoning. But unfortunately, that's one piece of the puzzle, no different than we could do everything that we can do over here, but as long as we don't have any enforcement, it's a moot point. But the other side of it too is that we pray that we do the right thing here, because if it ever comes to litigation, this is what's gonna help or break us. And just complimenting that, you know, we're all working as one to make this Los Ranchos a better place. And I think that's what I see that we're doing. Do we have different agendas? Do we have different ways of doing it? Yes. But I think the important part is that we're striving, and as we continue, I think that we're gonna be better for it.
Thank you. I really don't have anything additional tonight to mention. I just appreciate everybody's input and diligence in reviewing the documents. Thank you all for being here tonight. And our guests, thank you for coming. And of course, staff, and thank you for everything you've done to help advise us and lead us and answer the questions. Looks like we'll be back here next week. Look forward to seeing everybody then. And with that, we conclude our meeting, and it is 7:58.